Okay, Bismillahirrahmanirrahim. نحمده ونصلي على رسوله الكريم أما بعد. So in our last class, we discussed the purpose and effect. So I just only talked to you about, what exactly means purpose and how do you identify purpose in a contract, and how do you identify the effect in a contract. And also I talked to you about there are several kinds of contract whereby you can actually find the purpose and effect. So we talked about the counter values, exchanging counter values, which used to be the purpose, and transferring the ownership after the exchange, the transferring the ownership, whether it is a property you are transferring to someone, or you are the person who takes money for the property, which means that you are also becoming the owner of something. When you are making someone owner of your property, at the same time you are actually also becoming the owner of something, owner of money. So there is always transferring the ownership. So this is what actually we call it effect. Yeah, and then we talked about the lease contract. Also we talked about the other contract like kafala, wilaya. There are so many contracts that we talked about. Let's say we talked about the lending and hawala and kafala. So this is all examples of those contracts. We also ask you to do an individual assessment, whereby you've been following these 7 types of contract and classification based on these 7 types of contract, whereby most of you, I think, are using this. The first one, because acquiring ownership is something that is broad, whether it could be anything that you are selling, any kind of contract or sale or rent, gift, even waqaf, even in fact you are actually offering some services. Yeah, some of you ask me about services like repair, that kind of thing. Everything is actually comes under this number 1, because the thing that you are actually providing your skill, so that you are actually providing something in exchange of money. So you give your service so that you are taking somebody's money. So you are becoming owner of the money, and then the opposite, the customer becoming owner of your skill for that particular time. So this is also service oriented business, service oriented skills, and everything comes under uqud tamlikat. Yeah, so we talked about these 7 types of contract. We talked about the ownership, acquiring ownership, waiving rights, authorization. Then we talked about the imposing restraints at the qidat. Then we talked about the providing security. This is another kind of uqud that examples like kafala and hawala and pledge rahnu. Then we talked about the partnership. Even the partnership, still, if you are doing your assessment, for example, if you want to become the driver, like for example, you want to become the Grab driver, then you will come under number 6. This is like partnership. What we call it today, we call it sharing economics. For example, you have a product and you want to sell your product using some e-commerce platform. Yeah, so you don't have your own shop, but you are using their platform to explore, to advertise your items. Similarly, you have your own car, and then you want to become the Grab driver, and then you are using some platform like Grab or Uber, and you want to become available for services. So it's like, it is like a sharing uh, contract. So it will come under musharaka mudaraba, right? So there are several business today like this. For example, another example I give you. Let's say you have a house, and you want to propose it for accommodation, so that you are approaching like a platform like a Airbnb. For example, Airbnb. This Airbnb is today is actually exploring. It's showing your properties to the people that who wants to stay in your house, so that it's like you are sharing the profit among you and that platform. You got it? So these are the examples today. There are so many other examples also you can get. So these are the things will come under what we call it today, sharing economics, right? Shared economics, what we call it. But this is also a partnership. Yeah. Similarly, it goes to let's say you want to buy for example, you want to buy some share markets. Yeah, some sort of commodity you want to achieve, you want to buy. So these are the things will come under the partnership, right? But a person who wants to go and use the service, for example, as a customer, you want to use the Grab service. Okay, that one will not come under partnership. That one is actually renting. Yeah, so it will come under number one, right? So you need to understand the differences. Yeah. So let's say you want to buy something, you want to rent, you want to go from place A to B, and you want to use a car. Then the contract between you and the Grab driver is actually renting. But here we are talking about the contract between the Grab driver and the Grab company. This is what we call it, shared economics. Yeah, it is actually will come under number 6, uqud al-ishtirak. Yeah, so there are so many examples. Similarly, you can go for providing security. You want me to give you an example? For example, you have your computer system, and then there is a company who wants to take care of the security. Yeah, so you have a company, and you have a company, you have like more than 10 to 20 PCs, and then there is a company who wants to provide security. It could be online security, not necessarily it has to be only the physical security. Yeah, physical security is one thing, but nowadays we also need a security from hackers, because there are so many scams, this nowadays. So there are many companies providing like a firewall, right? The company, there are several companies are today, like for example antivirus. Yeah, so these are the things also can come under providing security, right? This is also like, for example, today everything online. This is also considered, for example, your phone. There is a these are the things might be comes under providing security. So there are so many examples, contemporary examples. You can actually get it, waiving rights, even authorizations and all. So you can actually do it in your individual assessment. So going back, there are a few other a few other slides that the other day I didn't cover. So today I'm going to give you the complete picture of this subject, the purpose and effect. So we are going to talk about the expressions and the hidden intention. So this is the most important part of the course. The reason we are talking, so this is what we are going to talk about today: the expression and hidden intention, fictitious contract. Yeah, and then we will talk about a couple of fictitious contract, artificial contract, like duress, mistake, fraud, deception. Yeah. So overall, we are going to talk about uh, something that all entire three pillars of the contract already completed. So right now, because previously we talked about three pillars, we talked about the expression, parties, and the subject matter. So what all of them are completed? All of them are completed. So right now we could say that uh, the contract is valid. But what if the intention is not the right intention, right? So for example, if someone is buying grapes from someone, but outside he did the expression and he is the eligible party, and then the stuff that he is buying is a grape, is a grapes. The grapes is actually something that valuable property. I mean the subject matter. So now three pillars are already there when someone is buying grapes, but his inner intention, right, is something that actually he wants to do it. He wants to use the grapes to make some alcohol. So now it is called unlawful intention. So we are going to talk about the expression, which is irada zahiriya, and the hidden intention, which is irada batiniya. Right? So this is a question now. So you have done everything, fulfillment of the competence. There's a parties and the existence of the consent, and then the property is there. Do we need to look the motive? Do we need to look something behind the intention? This is also something similar to the purpose, right? Why? What is the purpose that he wants to buy this? For example, you have a grocery shop, and then you also selling some knife. So someone comes and then it's okay, Nazrul, no problem. And also someone wants to buy knife from your shop, but his intention is actually he wants to kill someone. Yeah. So now whether I can buy knife or not, of course, because there are so many good things that I can do with knife. I can buy knife to cut vegetables in my kitchen. Of course, I'm baligh, I'm adult, I can buy. Of course, I have expression. I went there, I said, okay, I want to buy this knife, how much it is. So now it looks like all three pillars are completed. But if you look at my motive is actually I want to kill someone. So now, how do we take this? Is it sufficient for the validity of a contract to fulfill its pillars and conditions? Or it should be concluded for a purpose for which it is intended by Sharia? So now we are talking about the halal purpose. What it is, if he wants to buy a halal product but for haram purpose. Do you understand my point? So you need to understand this question properly. Then only you can understand the rest of the slides. That's why I want to clearly give you the scenario. So now I want to buy an halal product like grapes, a halal product like knife, but with haram intention, with haram purpose, with prohibited law, sorry, the prohibited motive, which means that I want to, the reason I buy grapes because I want to make wine out of it. I want to buy this knife because I want to kill someone. So there are so many other examples. There are so many products right now today available that people using it for unlawful motive, unlawful, purposes and intentions. So now the question is, all contract has been fulfilled its pillars, but What about the purpose? Does the existence of unlawful motive behind a lawful contract make a contract invalid? This is the question, right? There is an unlawful motive, which means that I want to make wine. This is unlawful motive, but there is a lawful contract. Lawful means halal. Okay, lawful contract is actually I'm buying grapes, but my motive is unlawful, which means that I want to make wine. So now, what exactly will happen? What is the opinion of the scholars? So now, according to Shafi'i and Hanafi, you can see this. According to Shafi'i and Hanafi, motive is something hidden and is left to Allah subhanahu wa ta'ala. So this is something that we need to understand properly. It doesn't mean that they are allowing this kind of act, but you need to understand the law. There is something that you can do within the law, right? There is something that you cannot do because it is beyond the law, right? For example, there is a possibility that you might kill someone when you are driving your car. There is a possibility. There is a possibility that someone will kill when you are driving. When you are driving your car, you might kill someone, but it doesn't mean that the law will stop you driving, right? The law will allow you to drive, but you have to be careful. If in case you kill someone by driving, then the law will come back and enforce its laws and then says, okay, you have committed a crime. So now the law cannot stop you while you are driving. The law can only stop you after you drive. I mean, after you kill someone when you are driving. So similarly, it goes to, the law cannot stop you, window shopping. Maybe you have the intention to steal something. For example, I'm going to the shopping mall. My intention is actually to steal something. But the law cannot stop me entering the shopping mall, cannot stop me until I go to the shop and then I steal something. After I steal something, the law can enforce, and then the law can stop me. The law actually can can stop me, and then can put me in the jail, in prison. Anything can happen. So this is where you can understand the differences. Yeah. So now look at here what Imam Shafi'i and Hanafi says. They don't look beyond the agreement or the hidden intention. They say that the Sharia requires that the parties enter into contract by mutual consent and fulfill all the pillars and conditions of a contract. Thus, this is an example. By al-aina is the sale of the grapes to a person who would make wine. The sale of arms during the civil war, for example, today you can see that the civil war happening, for example, between Palestine and Israel. And also Ziwaj al-Muhallil. This is something, Ziwaj al-Muhallil means what actually? It comes when someone divorce, and then after, for example, the first time and the second time, when it goes to the third time, when someone divorces the same wife for the third time, in Islam, if you divorce first and then you can actually get it back, you can get back. Second time also you can get back, but the third time you cannot get back unless unless they have to separate, and then they have to remarry someone, and then if in case they got separated again, I mean those new couples, then only this couple can get married again. So this is what the rule. So now Ziwaj al-Muhallil here is actually something that, you know, someone, you make someone to marry, you make someone to marry her, meaning the wife that you divorce for the third time. You make someone to marry her, and then he marry her, and then the next day he he divorced her, and then you go back and marry her again. So this is what we call, you make someone to marry her and then divorce her. We call it Ziwaj al-Muhallil, right? All these things contractually valid. All these things look like contractually valid, although they are makruh tahrimi to Hanafi and haram to the Shafi'i if the parties intend to use them to obtain an unlawful purpose. So now here I'm talking about the act. If you look the act and then you look the contract, so you can see that there's a contract, and then there is an act. So if you look in a way of contract, it is valid, but the act itself, the action itself is haram. So this is where Imam Shafi'i and Imam Hanafi, they are actually separating. They say that we cannot stop your contract because your contract looks like valid, because you have all the three pillars, and we don't look into your hidden, because your motive is hidden. We cannot see your motive, right? Whether you want to buy the grapes for wine or to eat something, you want to buy this knife for this, or you want to sell these arms, the weapons during the civil war, even this Ziwaj al-Muhallil, all these things looks like the contract is valid, but the hidden intention, it is something that we leave it to Allah subhanahu wa ta'ala, because only Allah knows what you think, right? So now they say it looks like the contract is valid. Legally speaking, it is valid. Legally speaking, I can allow you to drive. Legally speaking, I can ask you, I can let you go to shopping, window shopping. But the act of this, the action that you are doing, it is fundamentally haram. So here you need to understand, the contract could be valid, but the action that you are doing, the intention that you are having, this is between you and Allah subhanahu wa ta'ala, which is completely prohibited, which is completely haram. So now it is up to the person to choose it. So if I do this, then I have to answer to Allah subhanahu wa ta'ala. So this is where my sins are counted. My sins are so this is where actually so many examples can be given from this scenario. It's like, people who actually ask for the bribe. Yeah. So you can see that, they say, okay, you pay this money, and then you pay this much amount of money, then I will do the job. But the intention inside is actually bribe. But from outside, it looks like a contract. Right? You can see that. So many places is happening. From outside, it looks like a contract, but intention is actually bribing. Similarly, going to the corruption, the politicians are doing corrupt. All this goes under this. Right? If it is a police or the lawyer, whoever it is, if they are, it looks like outside, it looks like a contract. Even sometimes, even the administration of anything, for example, a company, right? They are actually overbilling, for example. Overbilling, for example, they say, okay, I order this commodity, this product from you, but when you are sending your invoice, make sure that you put extra money and you pay that extra money to me. That's because I gave you an opportunity to sell your product to this company, right? For example, usually you buy usually you buy the stationaries for 10 ringgit. So now this time you put 15 ringgit. You put 15 ringgit in your invoice, so my company will pay you that additional 5 ringgit. Later you pay me back. Later you pay me from some other. So this is actually corruption. Even it is small. Even it is small 5 ringgit, it is corruption, because in the name of the company, someone is actually using additional that 5 ringgit and putting in his pocket. So from outside it looks like a valid contract, but according to Shafi'i, this is haram. To do like this is haram. This is where actually corruption starts. Corruption doesn't start actually like millions and billions. Corruption starts from small. What if someone is actually corrupted, and then he is actually just takes only 5 ringgit per stationery? What if the same person taking this 5 ringgit every week 10 times, every month 40 times, every year 56 times? So you just do the calculation. So now every year and year and year is the money that he is collecting through this corruption is actually will go for millions. So now whose money it is? It is the government money, or the company money, or the people's money, or the taxpayers' money, but it is not allowed. In a paper it looks like a contract, but you call it commission, but you've already been paid for salary. When you are being paid salary, how can you actually take additional money from this stationery? So this is all an example, so many examples that you can give. So according to Imam Shafi'i, it is haram to do that. Yeah. And then according to Maliki and Hanbali, on the other hand, looks at the cause and the motive. This Maliki Hanbali, they say straight away, they say it is haram. Even they don't want to give an opportunity like Hanbali and Shafi'i. They say the cause or the motive of the parties. Thus, if the cause or the motive is unlawful, the contract is also unlawful, and vice versa. For example, they do not allow the contract of gift when such gifts are given to the people in authorities. Right? Even this authority, you go and you see a politician and then you bring something to him. See, frankly speaking, obviously it looks like you are giving him something because of his position, and that is actually something that prohibited. Why? Because the reason you are giving him, definitely you want to have something back. So this is what they call bribery. They are arguing that the permitting such contract would promote prohibition, and since they therefore use the juristic method of blocking means. So this is also they are bringing a fiqh, an usul al-fiqh. They say sadd al-daraya. I think we talked about this, sadd al-daraya, when we talk about the secondary sources of Sharia, which is usul al-fiqh. So we talked about the blocking the means. So according to the blocking means, they said this kind of contract should be prohibited. Right. Okay, then we are talking about now fictitious contract. So all these fictitious contract is actually, it happens when apparent intention, irada zahiriya, is present, but the hidden intention is absent. So this is what we call it fictitious, artificial. In Arabic also called sawriya or suriya. So this is all when the parties, when they are making this offer and acceptance, they don't have the intention really to make this. So meaning to say that there is a buyer and seller, maybe only the buyer wants to have something, he has intention, but the seller, he doesn't have intention, but it's happening. Meaning to say that this is where actually mistakes happens, deception happens, cheating happens, right? So when someone come and say, okay, this is a very good phone, this is the original phone, and then he wants to sell this to you for 3,000 ringgit, but his intention is actually cheating you. He wants to cheat you because it's not the original phone, it's a duplicate phone, it's a fabricated phone. So now this is what we call it fictitious and artificial contract. The examples of the artificial contracts are contracts that are concluded by persons who are minor, insane, drunkard, sleeping. Because these minor, insane, drunkard, sleeping people, they don't have the intention to sell something because they are minor, they are insane, lunatic, someone who actually voluntarily drink. So they don't have the intention to sell, but if there is a buyer wants to sell it, so it becomes artificial contract. Contracts made by mistake, coercion, and contracts made for an unlawful purpose are considered artificial. So there are four kinds of, four factors you may call it. There are, because when the consent is defective, the consent, when the consent is not proper, even though we understand that it is a hidden intention, hidden agenda, but when the consent is defective, the contract cannot be valid. Yeah. So there are four factors that we are going to talk about. How do we understand the consent is defective? So these are the four scenarios. We'll explain you how do you identify the consent is defective. The first one is duress. So duress means someone is actually forcing someone to sell. For example, you have a gun point and then you say you have to sell, or not necessarily the gun, maybe some other things. If you don't sell this, I won't be friend with you. If you don't sell this, I won't let you study with me. If you don't sell this, I won't show you this. So these are the things. It's called actually forcing someone to sell, or maybe threatening someone. For example, if you don't sell this, it's like in the movie, yeah. If you don't sell this, I will kill you and your family. Right? So these are the threatening with death, or the deprivation of his limbs. Maybe he says, okay, well, one of your part of the body, I will cut it down. If you don't sell it, to me, I will cut you. I will chop your hand. These are the things like, or severe beating, which may result in his death. So these are the things what we. So here we are talking about the real duress, yeah, the real forcing, the real threatening, not like not like a school boys, like okay, if you don't give me, I won't talk to you. If you don't give me that, I will complain to you, to the madam, to the teacher. Not like that one. Yeah, this is the real threatening issues. This type of coercion destroys consent, because when you are pushing someone to sell, he or she doesn't want to sell something. He doesn't have to sell something, but she or he only selling because you are threatening her or threatening him. So now this is completely destroying the consent and invalidates a person's choice. Duress does not destroy the capacity of a person, but destroys his consent. Maybe they are adult, both of them are adult. So it's not destroying the capacity. Capacity means the legal capacity. Yeah, we talked about before the ahliya, right? Ahliya. So the ahliya, there is no problem because both of them are actually baligh or adults. But the problem is actually with their consent. You remember we talked about it. There must be exchanging core values based on mutual consent. The consent mutually must be there. Mutual consent means what? Both sides. Like Allah says, an taradin. This word tarad is actually not only just consent. This is actually consent from both parties. The seller should have the consent that he wants to sell, and the buyer should have the consent that he wants to buy. So both consent comes together. So in this case, duress, there is no consent. That's why if there is no consent, if it destroys consent, then the contract is invalid. Okay, maybe today he might be sold, he might sold his property to someone because of the duress, but tomorrow he can go back to the court and then to the police and say he took my property without my consent. If he can prove that, definitely the property must be returned back. That's because The Sharia court will tell that, you know, this kind of contract is actually, it's not valid. But there are some conditions, you know, because this kind of force, this kind of duress must be something that reasonable, not like, as I told you, something that is not serious. It won't come under this. It must be serious. The one who uses force is capable of implementing his threats. The person forced is certain that the one who uses force would implement his threat. The nature of threat is such that it really endangers life. The threat is immediate, not like I will do this next year. If you don't sell this one now, so it has to happen immediately. That's why the threat is immediate. The force is used for an unlawful purpose. That's why it's not like for the lawful purpose. If it is a good purpose, it's okay, but it is not, should not be unlawful purpose. To the majority, the contract is void. If this condition fulfill, the majority says the contract is not valid. Number two, this is the second factor that actually you have, this will prove that there is a defect in the intention, in consent, deficiency of consent. The second one is actually mistake. This thing actually usually happens because, you know, sometimes you buy something and then you go home and you open the box, something else, right? It's not actually, we call it cheating. This is not, it won't come into the cheating. It's like you really wanted to buy, the gold, but suddenly you go home and you open, you saw it was silver. It was not the gold. Or sometimes you really wanted to buy this particular, it happens a lot. You wanted to buy a particular color, but you go home and then you open the box, you saw a different color. So we call it mistake. So we need to understand here what kind of mistake will cancel the contract, will invalid the contract. What kind of mistake will not cancel the contract? So here we are talking about two different things. One is actually with substance, the other one is actually with attributes. For example, you know, when the product is actually changed, you can see mistakes refer to both mistake with regard to the substance of a thing and mistake with regard to the attributes of the thing. So substance is actually something that, you know, completely changing. For example, in the place of gold, you saw silver. In the place of shoe, you saw the slipper. In the place of the phone, right, you saw for example, you saw the computer or you saw the laptop. So this is the different substance, right? Attributes are something that actually you saw the same thing, you saw the same shoe but different color, you saw the same phone, similarly the same variant but different color, right? So you saw the same product, same, for example, same flour. For example, you wanted to buy the wheat flour but particular company, but you saw it, we opened the same flour but different company name. So this is what we call it, changes in attributes. Okay, when a mistake is with regard to the essence of a thing, for example, when the seller think he sold a thing made of silver but the thing turned out to be the gold. So this type of mistake invalidates. This type of mistake invalidates the contract as it is void ab initio. We need to say it is not originally what you wanted to buy. Void ab initio means it is not what actually you wanted to buy. The originally this is not. So the substance of the product has been changed, meaning to say that even though you realize that later, so it is not actually your product. So meaning to say you can actually cancel, you of course the contract did not happen. The contract, according to Sharia, it didn't happen. So meaning to say both of you must come back again, and then either you can exchange with the rightful product, or you have to cancel the product and take the money back. Yeah. The next one, mistake with regard to the attributes of a thing, refers to a mistake where, for example, the buyer bought a certain product with one color and later he noticed that it is a different color. The validity of such conduct depends on the approval of the party who may suffer from the mistake. Maybe it's up to you now whether you want to keep the same color, it's okay, tapala, tada masala. You want to keep it, is okay, fine. But if you want to change it, you have the option, you go back and you can change it. It's not a problem. Yeah, but it won't invalidate the contract. Number 3, this is a factor number 3 which will show the deficiency in your consent. It is actually something what we call it fraud. It's a tadlis, which means that it's a kind of cheating. It refers to a situation where the performer of a contract is made to believe that the contract is in his interest, but in reality it is not. So it is what we call cheating. It looks like that he sold to you. He said, okay, this is the product. Look at this. Look at this phone. This is the phone that I want to sell you. I give you for 1,000 ringgit. This is a very, very good phone. So you check the phone, very nice, very good, right? But he actually he doesn't want to sell that phone to you. He wanted to show you the trial of the phone, which is the original phone, but the one he wants to sell to you is the different grade or different quality of the phone. So his intention was actually wants to make you believe that you are buying this, but when you go home and open, you started using the product, it's not like the product that he showed to you. So he wants to make you believe that you are in his interest, but in reality it is not. So this type of fraud is actually, you can have an actual fraud, you can have there is also verbal fraud. Actual fraud refers to a situation where the person through his action changes the subject of the contract with the intention to cheat another person. For example, you know, he wants to sell a car to you. He says a brand new car, but it is an old car, but he actually painted. He put the new painting and then he changed the numbers inside, you know, the meters and everything. Look like a mileage, changing the mileage. It looks like a new car. According to the majority of the scholar, this purchaser has the option to return the thing. According majority, because this is not the thing that you bought it, because you made to believe that this is a new product, but it is not. So this is what we call actual fraud. This is what we call actual fraud. According to a majority scholar, he has to return the product. But according to Hanafi, he says, yeah, he has to return the product. Not only returning the product. According to Hanafi, they say the purchaser, the one who bought, is entitled to compensation. This is good. You know, the compensation, the penalty. So meaning to say you have to get a penalty, a compensation from the seller, because the seller made you believe that you are buying the rightful product, but it is not, which means that you are entitled to compensation. And then you have the verbal fraud, is where one of the parties tries to convince another party by words. So this is actually only by word. See, the before the one is actual, here is actually word. For example, he gives the wrong information about the product. He says that, okay, you have this drink I'm selling you for 50 ringgit. This bottle of drink is actually something very good for your health. You know, it will take you away. It will take a coronavirus away from you. You know, this kind of wrong information. If a seller says another person's offer such, even sometimes you say, okay, this product is actually sold in the market for this price. Let's say everybody is selling like 60 ringgit. I give you for 50 ringgit. So these are maybe in the market also sold for 50 ringgit, but he said it's like 60 ringgit. So he described things like different price and everything. Definitely this action is prohibited because even cheating in the word, even wrongful information also, it is actually something. So this action, this act is actually prohibited, but it does not affect the validity of a contract, because you are buying something is the real product, you are buying the product, but he gave you the wrong information about the product. But the product is a product. The product is not actually the wrong product. The product is not actually different product. It's the same product. Only the price is actually, he gave you the wrong price. He said that this product everywhere they're selling for 70 ringgit, I give you 50 ringgit. But the truth is everybody is selling for 50 ringgit. So, but the problem comes when he sold the same product for higher price than market price. For example, previously he told that this product is everybody is selling 70 ringgit, so I give you 50 ringgit. This is fine. Even though others are selling 50 ringgit, it is fine. Even he gave the wrongful information, which is actually wrong, but it will not invalidate your contract. It will not invalidate your contract. Your contract is valid. But if someone is actually saying this, everybody is selling 70 ringgit, I give you for 50 ringgit, but in the reality, the product is only 20 ringgit. In the reality, is only 20 ringgit, but he says that everybody is selling 70 ringgit. But everybody is actually selling 70 ringgit, but this guy wants to sell to you for 50 ringgit. So this is a wrongful information. Not only that, it is a higher price than the market price. So here, two things combining. Number one is actually fraud, which is actually verbal fraud. Number two, it is also deception, which is deception means ghuban fahish. This deception is actually what we are going to discuss in next slide. Yeah. Fraud may also happen when a seller does not disclose the defects of the sold goods. You know, when he is selling, he actually wants to hide the reality of the product. He doesn't tell everything to you. For example, when he wants to sell a car to you, he says the car is very good, but he hides the truth that this car was undergoing some accident. So there were some accidents were happening to the car. He did not expose the truth. But later you came to know, which means that you have the option of defect. We are going to also talk about the options, meaning khiyar, where you will talk about again this one. You know, if in case you understood that the product that you bought, there is a defect in the product, you are entitled to return, right? So in this case, the purchaser has the option of defect, which entitles him to either approve or cancel the contract. So this is the last one, deception. This deception is actually something we call it ignorance of the buyer. There are two types of deception, yasir and fahish. Slight deception means, you know, if someone buying a thing 10% more than the market price, still the contract is valid. Sometimes you buy a product from supermarket and then you buy a product, the same product in the airport, you know, slightly difference are there, right? So we call it a slight deception, yasir. But there is a serious deception, fahish, meaning the deception is serious, the contract can be invalidated on that ground. So now, according to Hanafi, they are clearly making this sense. They say that, you know, the deception itself cannot entitle the cheated party to cancel the contract. The deception, because sometimes the deceptions are there, maybe he gave you the wrong price, higher price, but you need to understand, if he gives you the wrong price together with taghrir. Taghrir means wrong description of sold items. He says that, okay, everybody selling this product for 50 ringgit. I want to sell this product for 100 ringgit. The reason I give you for 100, because this product is different from other product. How? Because this product has so many other ingredients inside. This product is different from others. Maybe this product is actually imported or exported. It comes from foreign country, and it has a value in it. But the truth is he is selling the same product, but he is giving you the wrongful information. At the same time, he is selling more than the market price. See, two things together: selling more than the market price. Number two, he gave you the wrong description. Then according to Hanafi, he says, yeah, this contract will be invalidated, right? um, but there are some exceptions with regard to the properties owned by Baitul Mal, Waqaf, minor, lunatics. This is not the normal circumstances. If there are some properties owned by Baitul Mal or Waqaf, where the mere existence of ghubun also will invalidate the contract. So this taghrir and ghubun, remember the ghubun and taghrir must be combined in order to become invalidated. But when it comes to Baitul Mal, not necessarily it has to be, because Baitul Mal, everybody has to safeguard the Baitul Mal and also the properties of the minors, right? In this case, even the mere small ghubun also will invalidate the contract. According to the Hanbali, the existence of ghubun, whether accompanied by taghrir or not, it will affect the validity of the contract. So the buyer, according to them, has the right to cancel the contract. In case of talaqi rukuban najish. Okay, talaqi rukuban means when someone is actually selling, meeting the seller on his way to the town and buying from him the commodity before the seller has ever a chance to reach the market and to know the actual price. This is what happens when someone coming to sell something to the Slayang market and someone stopping him and buying all the vegetables before he reached the market, and then take that thing and then coming back to the, so meaning to say the seller, he must know the real price, but he doesn't. In this case, the seller, he doesn't know the real price because he didn't reach the market, but someone stopped him before that, which we call it talaqi rukban. Najash means it refers to an increase in price by third party who is not actually buying but wants to encourage others to offer a higher price. This najash also might happen when you go into the lelong auctions. Then you will see that there is a person will come immediately. He will say, I want to buy this. This is a very good product for 50 ringgit. So now his intention is not to buy, his intention to make others to buy. So this is what we call it a najish. So this is the inside game. The buyer will appoint someone to come time to time and tell that this product is very good. I bought this product, This is what we call inside game. Okay. So to the Shafi'i, a person cheated should have known the actual price or should have asked those who had experience. The Shafi'i attributes this to the fault of the party cheated. The Shafi'i therefore do not give the option to resign the contract. This is something different. This is also according to Shafi'i. I feel bad because according to Imam Shafi'i, he says that you should know better. So according to Shafi'i, he said you should have the knowledge of the market. If you don't have the knowledge of the market, if you lose something, you lose it. You will never return back. You will never get back. So this is what Imam Shafi'i says. So according to him, better we learn the market before we go to the market. According to Imam al-Ghazali, he also said learning the market is actually wajib. Learning economics is actually wajib. Learning the market price is wajib, so that you won't be cheated. Even today, I would suggest you that, if you buy anything, even you go to the market, you want to buy something from the shop, you always have your phone, you check the price in the shopping, online shopping, how much it is. You can compare the price. You can see the reviews. This is the beauty of today. Because today, it's people are, of course, become cheated. It's because of their they become cheated because they because of their innocent. They don't know how to check the proper price. But now we have many options to check the proper price. Even we can go back and check the reviews before we buy. And the one thing that you have to make sure that you should not hurry when you are buying something. You have to wait and see the prices, the reviews. If you want to buy some phone, Don't just go and buy. Wait for the reviews. Go for it. Choose the rightful product. Choose the rightful seller, and then look for the views that people, how much people they encourage to buy, and then you decide to buy. So today, of course, learning, like what Imam Shafi say, learning knowledge is very important. But others they say that the other they say, for example, Hanafi, they say if the ghubun and taghrir comes together, then it is invalid. Okay, so that's all from me. So if you have any questions, please go ahead.